How do I get custody of my child if the custodial parent is not keeping the child safe? What a great question. Not because it's a great question itself, but because it's so poorly worded. The best way to phrase this question is as follows. How do I get an order awarding custody of our child to me if I assert as the basis for my petition that the custodial parent is not keeping the child safe? Why is this important? As an attorney who gets this question frequently, the first things I tell people who ask that question are, is the non-custodial or custodial parent, as the case may be, in fact not adequately protecting the child in keeping the child safe as you assert? Could reasonable minds differ as to whether the custodial parent truly is not taking at least minimal actions to keep the child adequately safe? Or are the bases for your assertion, even if you could prove them as a matter of fact to be true, simply not reasonable? For example, parents have come to me asking if they could seek a change of custody or visitation, also known as parent time, because the other parent started drinking alcoholic beverages. Just started drinking, when previously, before the divorce, neither parent drank alcohol, perhaps as a matter of religious beliefs or health consciousness. Not that the parent has become a drunk, but just simply drinks alcoholic beverages. That's not a winning argument for a change of custody. That's not enough to prove the child is in danger. Another example, the other parent has started dating or living with a convicted felon. As long as the convicted felon is behaving himself or herself, conducting himself or herself in compliance with law, and not barred from being around minor children as a condition of his or her parole or release from prison, another parent dating or living with a convicted felon is almost certainly not going to be a sufficient basis for seeking a change of custody on the grounds that the child is in danger or not safe. Now granted, if the convicted felon is a multiple murderer or a snitch who is being hunted down by the mob, that may be enough for a court to determine the risks are too great to the child. But parents who come to me with the felony concerns are usually faced with a situation where the ex's new boyfriend or girlfriend was convicted of fraud, or the new boyfriend's or girlfriend's felony conviction took place so long ago and it wasn't that dangerous that nobody believes this boyfriend or girlfriend is the same person he or she was back then. Parents have come to me asking if they could seek a change of custody or parent time because the other parent lives in a, quote, dangerous part of town, end quote, or in a messy or small apartment. No sale. Unless you can prove that the conditions are so dangerous that it's just a matter of time until a child is harmed, or at least show that the risks or dangers to which the child is exposed as a result of where that parent lives, the court is just not going to make a change on that basis. Here's another option. What about a parent who has a dog as a pet and your child is allergic to dogs? That would depend upon how bad the allergy is. In my own life, I found out in my late 40s that I'm allergic to cats. That was news to me. We had a cat in the house when I grew up. I had friends whose cats I played with as a child. I never noticed, and still never notice, any harm come to me from being around cats or in houses or other places where there are cats. So if I were a child and my parents were divorced and Dad was the primary custodial parent and he owned a cat or two, would Mom be able to get a change of custody because I technically tested allergic to cats? I highly, highly doubt it. What about a parent who doesn't have the children bathe as often as you would like, or doesn't have them brush their teeth as often as you'd like, or if at all, at his or her house? Yeah, probably not enough to get a change of custody. Maybe if your judge is really into hygiene, but odds are against you. And even if it's true that the custodial parent is a danger to the child or exposes the child to unreasonably dangerous situations, if you can't amass enough evidence to prove it to the satisfaction of the judge, then mere truth doesn't matter. It's a matter of proof, being able to verify what you claim. Many times I've encountered cases where the parent and I knew the truth, but didn't have enough evidence to prove it. This happens a lot in situations of substance abuse and even physical abuse that can be explained away as being caused by something other than the abusive or neglectful parent. Bottom line, unless you have a legally sufficient argument that the child is suffering serious harm or that the child is in real danger of serious harm and have sufficient evidence to prove it, you will likely lose a petition to modify custody on the grounds that the custodial parent is not keeping the child adequately safe.